Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. So I'm still working on the municipal handguns ban thing, but it's a bit of a slog, and I've been doing Bill C-21 pretty much nonstop for a while now. So somebody sent me something. I want to share it with you because it's a lovely, refreshing break. I blacked out names for two reasons. One, I'm not really trying to embarrass anyone here, and two, I haven't been able to 100% confirm that this is a real document. It might be a elaborate and very well done, if so fake, but it was passed to me by somebody who indicates that it's real. I've got no reason to doubt them, but I'm still being cautious here. So let's go through this document because it is hilarious. So this is a fiat, and a fiat is basically a judicial pronouncement. It's sort of like an order, although it's a little bit different. I'm not going to go through the sort of the full distinctions here. So we've got F, who is for the plaintiff, and G, I think, for the defendant. And it says fiat February 18th, 2021. I think this is an application. I'm not sure. I think I'm supposed to rule on it, but I cannot be sure of that either. Confused, counsel? Me too. Here's why. Counsel for the applicant has not identified himself or herself. There are lawyers for the plaintiff. There are now lawyers for the defendant. On the sole document filed, which is a consent order, there is a notation that the consent order is prepared by the blank law office. Did they file it? I suspect so, but I just cannot be sure. I also noted that I think this is an application, but I'm not sure. We have rules of court. We've had them for decades. The current iteration came into effect in July 2013. Prior to that, the previous rules came out in 1981 and were amended from time to time until the wholesale rule revision occurred over 8 years ago. If I wanted the court to be sure there was an application before it and wanted an actual ruling on an application, as an enterprising and experienced lawyer, I would check those rules of court if I didn't know them already. Oh, I'd check them good and proper, by gum I would. I would scour those rules of court until I came to rules 6.3 sub 1 and 6.4. 6.3 sub 1. All applications must be by notice of application except where otherwise specifically provided. 6.4. Every application without notice must be by memorandum in Form 6.4 that sets out all of the following. I would then deduce, very cleverly, through applying all of my law-talking knowledge, that I have to proceed by way of notice of application unless authorized to proceed by way of an application without notice. While not specifically authorized, where the parties have reached a consent order, it is likely that such an application would be entertained by the court on a without notice basis. Here's what I wouldn't do. I wouldn't just file a consent order, all orphaned, no application, no affidavit, not so much as a cover letter. I wouldn't treat my application as a legal stick flung for a judicial dog to chase, catch, chew on, and figure out. The fact that it is a consent stick does not mean the stick should just be flung at this court in any event. As a good lawyer, I would, at the very least, do a Form 6.4 application. The court can then rule on such an application. The court cannot properly rule on a document carelessly flung in its general direction, with one of the lawyers yelling, "Fetch, judgy! Get it, boy!" The court will not rule on such a thing, even if it could properly do so. This judicial expectation does not place an onerous burden upon counsel. Form 6.4 is mercifully brief, consisting partly of ticking some boxes and partly of providing the most modest amount of information. It is not a Sisyphean task. It's actually pretty easy. Fill out the form. File the form. Work with me here. Fill out the form. File the form. Fill out the form. File the form. Eventually, it will become muscle memory. I know who prepared the draft consent order, but I do not know who filed it, and the local registrar does not know who to charge for this thing. I cannot say this application. I do not think it was Mr. F, because he acts for the plaintiff, and why would he file and pay for an order setting aside a noting for default? Just as an aside, a noting for default is in a situation where, for instance, you've been sued and you haven't filed a statement of defense in time. The other side can note you in default, which means that they win. However, those can be set aside fairly readily often if there's a good reason why you didn't file in time. The courts are not usually going to treat that super harshly. However, don't take anything as advice here because different jurisdictions have very different practices. If you get a statement of claim, talk to a lawyer immediately, if not sooner, because those deadlines can be a big deal. So that's just sort of what is going on here in terms of the order setting aside a noting for default. So Mr. F wouldn't be inclined to pay for that because they got the default because the other side missed their deadline. And so he's not likely to be the one paying for the other side to get the benefit. I suspect Mr. F is an innocent bystander, but the judicial shrapnel hurts him just as badly as it does the other guy. Yet I don't think it could possibly be Mr. G, because I know he had absolutely excellent instruction in civil procedure when he was a law student at the university. I'm just reading between the lines here. I'm just making a guess. I'm guessing that this student was educated in civil procedure by this judge. That would be my bet on this one. And so this is a little bit of extra snark. And law students, if you don't think that your professors remember you, I can guarantee you that a lot of them will. I reached out to some of my professors on occasion, in practice, and without fail, they all indicated, oh, we remember you. Although that might be more of a statement about me specifically. So maybe I'll just move on. Maybe I was particularly memorable for reasons that maybe I won't go into right now. All right. So I just don't know for sure who filed this. You know how I would know? If an application was filed, that would tell me, yeah, that's it. And the judge uses no fewer than 5 exclamation marks here. I know, counsel. You're thinking, oh, this judge is getting all self-important and uppity, doesn't want his delicate little judicial fingers to get chapped paging through the court's file, trying to figure out what is going on. Well, respectfully, you're wrong. The point of this fight is that standards of practice are slipping. No, have slipped, to the point that lawyers apparently believe they can fling some paper at a judge and he or she will treat it as a properly drafted application, rule on it, and approve it. You file proper applications, I rule on them. Come on, work with me here. You file proper applications, I rule on them. While this court has grown steadily more accommodating and less formal about its processes, there are basic minimums below which we cannot stoop. As in, counsel, you at least have to do an actual without notice application. It's about 1.5 pages long. Your legal assistant can do it in about 5 minutes. How about doing the application properly and resubmitting it, and at least pretending to be embarrassed about showing the court your shoddiest work? At least, I really, really hope this is your shoddiest work. If we haven't hit bottom yet, I despair. Formal ruling. Application rejected without prejudice to renew same by actually filing a proper application, yet with prejudice in the form of a small amount of judicial disdain. So without when they dismiss an application without prejudice, it means that the application isn't dead. You can refile it. So you can revive it by doing it right, which is what the judge is saying here. File a proper application. If they rejected it with prejudice, then the file would be over and dead. Obiter dicta, and obiter dicta is sort of a by the way. It's not part of the formal ruling, which is why the judge has separated it out. I'm not angry. I'm just really disappointed. So I've spoken before about how judicial snark is usually fairly understated and usually kind of a read between the lines situation. This is not so much a read between the lines situation. This is the judge being very snarky. And frankly, I find it kind of hilarious. Now, I find it kind of hilarious because I'm not one of the lawyers involved in this. I would be a lot less keen on this if I was one of the lawyers there. And it's worth noting that there's a bit of a power imbalance. In fact, there's several power imbalances here. First, those judges or those lawyers can't snark back to the judge. If they wrote like this to the judge, they might be found in contempt. And another one that I'll mention here is that judge doesn't really have the ability to snark back at me if they don't like what I say. So I'm always careful, more or less with my criticism of judges. I think it's fair to criticize their reasoning, but you can only go so far before you start getting into, areas where it's not fair and not really right. But I mean, it seems to me that this judge is not really just upset about these particular lawyers. It's more of a commentary in part on everything that's been happening. It looks like this judge is kind of annoyed at how things have been going generally, but that to me is a hilarious little bit of sort of judicial bomb dropping, essentially. And so I wanted to share it with you. It provides a nice light interlude while I get the full video on the municipal municipal handgun ban lined up. That's going to be a lot more depressing. It's going to be something I'm sort of less laughing about. Anyway, thank you. I wanted to share this with you. I hope you guys found it funny too. Please like this. Please share it with your friends. Subscribe to see more content. I also want to thank my Patreon supporters, D. Mo, Sir Daniel Wicks of Alberta, Canada's National Firearms Association, North Central Process Service, and Kyle Martin. And at all those at the $50 level, at the $20 level, Cameron Johnson, Dale Nesbitt, Andrew Elsich, and Sights and Arms Limited, as well as many of you at the $10 level who will be in the crawl immediately following. Thank you once again, and I hope this has armed you with knowledge, or at least been entertaining. So, thank you. Have a good night.